Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Lokpal and Lokayuktas Amendment Bill 2014. To discuss the issue, I have with me Mr. Anil B. Diwan, Senior Advocate, Supreme Court, and Ms. Amrita Johri, National Campaign for People's Right to Information. Now for the headlines. The leader of the single largest party to be made a member of the selection committee if there is no leader of opposition in the House. The bill seeks to ensure that under no circumstance the appointment of the Lokpal can be stalled. And all public servants may have to declare their assets and liabilities in public interest. The Lokpal and Lokayuktas and other related law amendment bill 2014 includes a provision where leader of the single largest party will be made a member of the selection committee if there is no leader of opposition. The bill amends the Lokpal and Lokayuktas law and other laws to synergise various aspects.
The proposed amendments seek to iron out the contradictions that exist between the Delhi Special Police Establishment Law 1946 and the Lokpal and Lokayuktas Law of 2014. According to the proposed changes, public servants may have to declare their assets and liabilities in public interest. This information would be published in the public domain, keeping in mind certain safety measures.
I would say that nobody envisaged when they were drafting the bill that there could be a chance that there would be an opposition party in our country who would not even get the minimum requisite numbers. So they could not anticipate that. But taking care of the fact that this can happen and this did happen, I'm glad that the opposition, although they are only in 40s, would get a chance, and that would strengthen the democratic ties and the strength of the country, which is very much necessary. And this whole concept of Lokpal and Lokayukt is very good for our country.
A public servant will have to give a complete account of all his assets to the competent authority within 30 days of his joining. The public servant will have to give an account of his immovable property. He will have to disclose his inherited property. Property acquired by the public servant will have to be stated. Property on lease or mortgage by the public servant on his name or in his family's name should also be stated by him. He will also have to submit an account of all his debts and other liabilities incurred by him directly or indirectly. The public servant should also provide information regarding movable property inherited by him, owned by him or held by him.
Already under the Representation of People Act, pursuant to the intervention of the Honorable Supreme Court, the Election Commission has issued guidelines. The Parliament has also enacted a section where affidavits for disclosure of assets are required. Now, if it is extended to public servants, it will also give a clear idea as to what his assets are, so that when under the Prevention of Corruption Act, you need to prosecute a public servant for owning disproportionate assets, this will be the benchmark.
The headquarters of the Lokpal may be located in the National Capital Region. The benches of the Lokpal would also sit in New Delhi. The Lokpal and Lokayuktas and other related law amendment bill 2014 was introduced by Dr. Jitendra Singh, the Minister for Personal Public Grievances and Pensions. The Parliamentary Standing Committee on Personal Public Grievances, Law and Justice is examining the Lokpal and Lokayuktas and other related law amendment bill 2014. One of the major issues that is being looked at in the bill is the declaration of assets of the spouse and the dependent children of the government employee. With cameraman MS Suresh, Dipali Pandit for Rajya Sabha Television.
The selection committee is to be headed by the Prime Minister. The other members include the Lok Sabha Speaker, the Chief Justice of India, besides the leader of the single largest party. Straight away the question to you, sir. Dilution part. See, disclosure of public servant under the Election Commission laws was already happening, as it was mentioned. If it has to be applied to all the public servants, and if they have to do it in public interest and the assets and liabilities have to come out in public, with safety measures is the clause that is there in the bill. Now, if there is a chance of, let's say, a public servant declaring assets and liabilities, and if someone kidnaps him in some hinterland, for ransom because he knows how much money he has or whatever he has and that he could be a good catch. How do you tackle a situation like this in this country?
First of all, Parliament, after the Supreme Court judgment, parliamentary candidates have been declaring their assets. How many of them been kidnapped?
Correct.
None. I've never heard of some parliamentary candidate or a minister being kidnapped. So I think it's only a theoretical thing, number one. Secondly, the flaw in the amendment is that now it restricts the disclosure to the person, the public servant, and omits the disclosure of the spouse
And the dependent.
and the dependent children, which is, I think, very retrograde. Because you can always say, this belonged to my wife, I didn't want to declare it, or my husband. So I think this something which has to be looked into, and it actually weakens the campaign against corruption. Secondly, I want to make a broad observation that this government, which promised the electorate that they'll go strongly against corruption, instead of removing the defects of the bill, have gone forward to further weaken it. So whatever was done in the past is now being amended with a view not to strengthen, not to remove what was, I said, which were shortcomings, but rather to weaken it further. So I think that's a broad thing which we must address ourselves to.
I'll get in, Mrs. Jory. Your inputs on especially the points made by Sir here, spouse, dependent, and also disclosure. To what level? Will it be 100% disclosure in public domain, or a part of it will be held back if the safety part requires it? In view of all this, how do you see the...
Yes. So the original act said, the original Lokpal Act which was passed, it actually said that all the public servants that are covered under this law, which is essentially all the members of parliament and all the senior bureaucrats, would have to declare all assets which are held by them or their spouse or their children jointly or severally, whether they are made out of the income of the public servant or made out of an independent income. Now, why was this disclosure important? This disclosure is very important because the Lokpal has been set up to receive complaints under the Prevention of Corruption Act. And the Prevention of Corruption Act says that a ground for criminal misconduct is owning property or assets disproportionate to known sources of income. So therefore, the only way to file complaints about disproportionate assets is if you have proper information on the declared assets of public servants. Now, case after case in the High Court and Supreme Court, we found that when you look at the cases related to disproportionate assets, usually those assets that are acquired illegally, are amassed illegally, are held in the name of the spouse or the children. I mean, you know, it would almost be a little counterproductive to hold it just in your name. You do pass it on and hold it in other people's names. So therefore, it was very important that all the public servants be subject to a very high standard of declaration, and also that this asset declaration be put out in the public domain, which was there in the original act. Now, why is it important that this information be in the public domain? So that people can actually look at these declarations and file well-informed complaints to the Lokpal. Now, what the amendment bill has done is that it has said that no, there will be no standard format of disclosure. Different public servants, which means that the members of parliament will be subject to the Representation of People Act and the bureaucrats will be subject to the All India Services Act. Now, if you look at the Representation of People Act, that again includes declaring assets owned by spouses or children. But the All India Services Act, which deals with all the bureaucrats, says that only assets which are owned by the public servant or the spouse or children but are generated by the income of the public servant have to be declared. Which means that the independent sources of income through which assets are declared, those do not have to be actually put out in the public domain. The big thing that they are citing is safety concerns, and like Mr. Devan just pointed out, that in fact we have seen that candidates have now been declaring their assets since 2004, people who are fighting elections to parliament, legislative assemblies and municipalities. So that means lakhs of people. All their affidavits are today in the public domain. There's not been a single case of harassment or of kidnapping. And it's not just candidates, but even judges themselves are today declaring all their assets and their spouses and dependent children. We don't have a single case.
The existing law has been diluted to a substantial level, and somewhere or the other, it is not going to help the government's agenda of fighting corruption.
Absolutely.
Correct?
Yes.
On this note, time for us to take a short break. Coming up, the bill seeks to ensure that the appointment of Lokpal is not stalled under any circumstances. Welcome back. The bill seeks to empower the central government relating to manner of recording and maintenance of the annual appraisal reports and similar activities. These rules will be made for carrying out the provisions of the law through notification.
The bill ensures that under no circumstance the appointment of Lokpal can be stalled. It proposes that absence or vacancy of any person in the search committee would not affect the appointment of chairperson, member or an eminent jurist. Absence or vacancy of a member in the selection commission or absence of a person in the search committee would not affect the appointment of a person in the search committee. One eminent jurist would be appointed by the members of the selection committee to be a part of the committee. The jurist may be appointed for a period of 3 years. The jurist once appointed will not be eligible for a second term.
The Ministry of Law and Justice maintaining the performance appraisal record of the Director of Prosecutions. The section says by rule the procedure will be prescribed. Care should be taken that under no circumstances the Director of Prosecution comes under the control of the government. The performance appraisal procedure should be so couched that the independence of the office of the Director of Prosecution is maintained. If that is done, the provision would be valid. Otherwise, I find that provision suspect.
The existing law provides for a Directorate of Prosecution to be headed by a director of the rank of Joint Secretary for conducting prosecution of cases. The bill proposes to introduce eligibility criteria for Director of Prosecution. He may be an officer from the Indian Legal Service holding the post of Joint Secretary. In case there is no eligible officer for the post of Director of Prosecution, then an advocate with a minimum of 15 years of experience in handling cases on behalf of the government related to economic offences related laws would be eligible for the post. In case there is a difference of opinion between the Director and the Director of Prosecution, the matter will be referred to the Attorney General, whose decision will be final in the matter. The Minister of Law and Justice shall record and maintain the annual performance appraisal report of the Director of Prosecution.
You need a judicial touch with the ruling party's participation and the opposition being on board. All three have to come together to have an effective Lokpal. Since, because of technical reasons, we don't have a leader of opposition at this stage. So they had to bring in somebody from the parliament, and the best way is to choose the representative of the largest party in opposition.
The amendments in the Act seek to remove the deficiencies in the existing Lokpal and Lokayuktas Act 2013. The amendments also ensure functional independence to the Director of Prosecution under the DSPE Act. The Lokpal and the Lokayukta Act provides for Lokpal at the Union and Lokayuktas at the state to inquire for corruption charges against public functionaries. Experts believe that this bill was long overdue and should be passed without any further delay. With cameraman MS Suresh, Dipali Pandit for Rajya Sabha Television.
Whom will the Director of Prosecution report to? Now that's the question. Do we have any indication, ma'am? Do we have any indication in the earlier bill that was passed or in this law that is existing and the bill that is proposed?
Yes.
Any indication who the Director of Prosecution will report to?
So what we believe, and that's what we've suggested to the government, is that wherever any officers are working on cases referred to them by the Lokpal, they have to be accountable to the Lokpal for those cases and for that period of time where they're working on such cases.
Do you see that reflection?
No, we don't see that reflection, and in fact what we find is that they are saying that the Director of Prosecution's APAR, which is their annual performance appraisal report, will be done by the ministry. Now that is a dilution of the of the sort of empowered and independent body that the Lokpal is envisaged to be, because that would essentially mean that they would not be accountable to the Lokpal. What we have suggested over there is that under ordinary circumstances, the Director of Prosecution of the CBI should be governed by the law governing the CBI. However, whenever this person is working on cases referred to it by the Lokpal, then while writing the APAR, the comments of the Lokpal must be sought and must be included in the APAR. This is the only way that we'll be able to ensure that there is administrative control and superintendence of the Lokpal over the officials working on it. Just another point that I wanted to add, that while the Lokpal Act, the original Act, said that the administrative superintendence of the CBI will lie with the Lokpal for the period of time that the CBI officers are working on cases referred to it by the Lokpal, and it also said that no transfer shall happen without the consent of the Lokpal. We believe that that should also be extended to other matters of even removal, because not just transfer, even removal must be with the concurrence of the Lokpal. This is very important, because if we look at it, what was the need for the Lokpal? The need for the Lokpal was that today there is no independent and empowered body to look into cases of corruption which is free from political influence. So there has to be a level of insulation that is provided to this body and to the officers that are working under this body, so that this body can work in an independent manner.
Sir, your take on this. An institution of Director of Prosecution being created, appraisals to be done by the government, reporting to Lokpal, Lokayukta for practical purposes or cases referred to them. Do you think this system will work the way it has been pointed out?
It will work in favor of safeguarding corruption.
So basically...
Very simple. I'll tell you why.
Yeah.
Why should the Ministry of Law and Justice come in? Number one. Secondly, we have always been advocating that the CBI anti-corruption wing should be directly under the Lokpal. That was emphasized by civil society and others, but never implemented. So government still wants to keep control over not only the Director of Prosecution, but also all the investigations by CBI.
Okay, I'll flip the question. If the government has to be accountable and responsible to the people of this country, and if that is the premise on which it forms the government, then in that situation, what is wrong if the executive or any kind of prosecution agency that be reports to the government? Aren't we fundamentally changing the reportage of the executive to a completely autonomous body and not to the government of the day elected by the people?
Yeah. Now, why is the Lokpal there? Because there is an enormous amount of corruption in government. So, by and large, people's perception is that government or government servants are under suspicion. Now, would those government servants itself control, or some autonomous body should control? Because you can't have a person who is a suspect controlling the investigation or controlling the Director of Prosecution. It's something which is inconsistent. You want to oversee, you want to scrutinize, and you want to bring them to book. Now, should it go back to the same people?
So we are assuming here
absurd. Therefore,
that
it has to be an autonomous body. And that autonomous body is conceptually the Lokpal.
Correct. Now, ma'am, the premise is, the assumption is that the government of the day is corrupt. And that is why we need to have an autonomous, completely independent body which will conduct the work of anti-corruption the way it feels fit for the, according to the times, right?
Yes.
If the government wants to keep control, what's wrong with it?
Yes. So what we believe in is that you cannot have an autonomous body that is not accountable to anybody at all. That in itself goes against the premise of corruption, which is that every body has to be accountable. So what we had suggested was that let the Lokpal function independently, let it have control over the officers working under it, but at the end of every year, let it lay a report before Parliament, especially in terms of its ethical standards of functioning, in terms of ensuring that there is, it is working according to what's laid out in the law. That is very critical because no body should be a law unto itself without being accountable to any other.
So a parallel judicial body reporting directly to Parliament?
Yes, so it could be that a report is laid in front of Parliament every year about its functioning. What is also required over here is that if we see what is happening is that the need for the Lokpal is something that in fact the party which is formed the current government was also very supportive of before it actually formed the government. So also if you look at it, that the Lokpal law was passed in 2013 and was put in the official gazette on January 1, 2014. Till date, it has not actually been operationalized, which itself raises a huge issue that first we had to have a huge public agitation to get the law in. And now what is going to be, how long do we have to wait for before this law is actually operationalized? The other thing is also that you operationalize a law, it is always open after that to look at if there are certain changes required. But to just not operationalize a law really raises
on the
questions
apprehension
about
that
the
it'll have problems.
Absolutely.
Okay. So the next question is the quorum of the selection committee. The quorum of the selection committee. So what the existing law says is that, okay, if anyone is avoiding or is not joining the selection committee or the position is vacant, still the selection will continue. Okay. But what it misses out to include is the minimum quorum for the selection committee. Do you see a reflection of that in the bill?
No, there is no quorum in the bill at all. So,
what do you suspect is going to happen? The way it has been codified right now.
no, they seem, see, I think this is being introduced because in the NJAC Act, the Judicial Appointments Commission Act, the Chief Justice has not gone to the selection committee until the case is over. So they are finding it difficult to nominate an eminent person there.
Correct.
So this seems to be addressing itself to that. But as you rightly pointed out, there has to be a quorum.
Correct.
Because you can't, one person can't decide, two persons can't decide, three persons, the political executive and the political opposition, at least on corruption or having shortcomings, they seem to be one. There is, opposition is only in name.
Correct.
Really, both of them want to weaken the bill. So this has to be safeguarded. I would suggest not only quorum should be there, but there should be also then, if you want a quorum, there should be some veto power also.
Okay. So how do you word it? Quorum should be there.
Yes.
But see, you have to ensure that the process doesn't stop. You have to ensure that everyone participates in the process and that the objective of the process is met.
Yes.
Correct? But how do you word the quorum part so that all this the actual process doesn't get affected and the objective is met? How do you do that?
So if we take a step back, so the selection committee earlier had the leader of opposition. There was a need for an amendment, a single line amendment actually saying that if there is no recognized leader of opposition, then the leader of the single largest party. Now instead of that single line amendment, what we see is a 10-page amendment bill that has been brought in. Now on this specific point, the wording is not the problem. It is very simple. It could have simply said
three people should be there.
No, or it could have simply said that a quorum of 2/3 of all members present and voting need to be there. I mean, it's standard legal language. I don't think that is
Why do you think they have skipped that?
So that is our big concern. And maybe like Mr. Devan pointed out that their experience of NJAC is what is leading to this. But really what is very dangerous is that the way it is worded currently, even one person coming for the meeting could actually make the appointment because there is no safeguard at all in the bill. There's just no safeguard.
Thank you, ma'am. Moving on, my colleague Dipali Pandit spoke to Geeta Luthra, senior advocate, to get her point of view.
Introducing the leader of the opposition or the person who is the leader of the single largest party should be something which is acceptable to the opposition. And because of that, the passing of the bill should become much easier and the implementation should become much easier. Now, even the other amendments, you see everyone is more or less committed or at least has to give lip service to be committed to the Lokpal bill. So on one hand, you can't have the AAP saying anything against it. BJP is itself not having anything against it. And the Congress will also have to toe the same line. Plus, the very fact that they are saying the leader of the single largest party is something which will be very palatable to them. So I see that the amendment would be taken well.
Thank you, sir and ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.